This is warm up. We're continuing with this article about DNA. So we're kind of in the middle. And I'll start at 180, but we'll try and push it past 200. We'll see how that goes. For the record, Barlow's main point of contention was statistics. Generally, juries in cold hit cases are told to rely on FBI estimates when weighing the odds of a coincidental match between crime scene DNA and the accused. When all 13 markers are intact, these odds can be as slim as 1 in many trillions. In Puckett's case, where there were only 5.5 markers available, the San Francisco Crime Lab put the figure at 1 in 1.1 million. Still remote enough to erase any reasonable doubt of his guilt. The problem is that according to most scientists, this statistic is only relevant when DNA material is used to link a crime directly to a suspect identified through eyewitness testimony or other evidence. In cases where a suspect is found by searching through large databases, the chances of accidentally hitting on the wrong person are orders of magnitude higher. The reasons for this aren't difficult to grasp. Consider what happens when you take a DNA profile that has a rarity of 1 in a million and run it through a database that contains 1 million people. Chances are you'll get a coincidental match. Given this fact, the two leading scientific bodies that have studied the issue, the National Research Council and the FBI's DNA Advisory Board, have recommended that law enforcement and prosecutors calculate the probability of a coincidental match differently in cold hit cases. In particular, they recommend multiplying the FBI's rarity statistic by the number of profiles in the database to arrive at a figure known as the database match probability. When this formula is applied to Puckett's case, where a profile with a rarity of 1 in 1.1 million was run through a database of 338,000 offenders, the chances of a coincidental match climb to 1 in 3. Such coincidental matches are more than a theoretical possibility, as Chicago police can attest. In 2004, detectives investigating a string of robberies on the city's north side found some skin cells that the culprit had left behind at one crime scene, which contained 6 DNA markers. When they ran this profile against Illinois' offender database, they found it matched a woman named Diane Myers. There was just one problem. When the burglaries in question were committed, Myers was already in jail, serving time on drug charges. Indeed, the little information that has come to light about the actual rate of coincidental matches in offender databases suggests the chances of hitting on the wrong person may be even higher than the database match probability suggests. In 2005, Barlow heard that an Arizona state employee named Catherine Tucker had run a series of tests on the state's DNA database, which at the time included 65,000 profiles, and found multiple people with 9 or more identical markers. If you believe the FBI's rarity statistics, this was all but impossible. The chances of any 2 people in the general population sharing that many markers was supposed to be about 1 in 750 million, while the database match probability for a 9-marker match in a system the size of Arizona's is roughly 1 in 11,000. Barlow decided to subpoena Troyer's searches. To her surprise, she discovered that Troyer had unearthed not just a couple of pairs who shared 9 identical markers, but 122. That was a wow moment, Barlow recalls. Studies of DNA databases elsewhere have revealed similar findings. In 2006, for instance, Illinois officials searched the state's offender database, which at the time contained 233,000 profiles. They found 903 pairs with 9 or more matching DNA markers. Among geneticists and statisticians, these findings have eroded faith in the FBI's DNA rarity statistics, which were based on data from just 200 or 300 people and are used by crime labs across the country. Lawrence Mueller, an ecology and evolutionary biology professor at University of California, Irvine, told me that anyone who knows statistics finds the figures laughable. Rather than try to sort out the disparities between its numbers and database findings, the FBI has fought to keep this information under wraps. After Barlow subpoenaed the Arizona database searches, the agency sent the state's Department of Public Safety a cease and desist letter. Eventually, the Arizona Attorney General obtained a court order to block Barlow's distribution of the findings. In other instances, the FBI has threatened to revoke access to the Bureau's master DNA database if states make the contents of their system available to defense teams or academics. Agency officials argue that they have done so because granting access would violate the privacy of the offenders, although researchers generally request anonymous DNA profiles with no names attached and tie up the FBI's computers, impeding investigations. These justifications baffle researchers. In the December 2009 issue of the journal Science, dozens of biologists, geneticists, and forensic experts urged the FBI to change its secretive policy, saying that there was no way that allowing a handful of researchers to run database searches, each of which takes only a few minutes, would hamper investigations. They also dismissed the agency's privacy concerns, saying the government frequently releases sensitive information under controlled conditions to verified researchers. Crane of Wright State University, who is the letter's lead author, believes the real reason the FBI has blocked access is to avoid revealing the shortcomings in its own system. Analysis of the offender database is sure to expose the misconceptions and errors in the method the FBI used to arrive at its rarity statistics. Since the crux of the government's case relied on DNA, Barlow knew that she had to get the data on the probability of coincidental matches in front of the jury to have a shot at winning. Beginning in early 2007, Judge Jerome Benson summoned the parties to his courtroom for a series of pretrial hearings, which were reported in detail by journalist Chris Smith in San Francisco Magazine. Puckett rolled himself in using a government-issued wheelchair, a Bible tucked between his thigh and the chair's frame. Barlow pled with the judge to let her present evidence challenging the government's 1 in 1.1 million statistic. The inability to reveal this information to the jury, she insisted, would violate Puckett's constitutional right to a fair trial. Prosecutor David Marin, who made his case through a combination of written motions and oral arguments, countered by presenting two seminal precedents from other courts which had refused to admit the database match probability, the 1 in 3 statistic in Puckett's case. He also called the Arizona database findings half-baked and argued that if Barlow's requests were granted, the trial would get bogged down in complex statistical debates that would likely cause a jury to throw up their hands in confusion. Barlow found this argument infuriating. Frankly, to sit here and say it would be too confusing for the jury is insulting, she seethed, according to San Francisco Magazine. If we can't present this evidence, then the case is gone. Okay, I think we'll go ahead and do tapes.
Are you sure you don't want us to read that back?
If you like.